That's one of the major issues that we're looking at today. The Governorship Election Petitions Tribunal sitting in Lafia, Nasarawa State, has sacked incumbent Governor Abdullahi Sule of the All Progressives Congress. The tribunal declared the governorship candidate of the People's Democratic Party, David Mbugadu, as the duly elected governor of the state. Abubakar Abdullahi sent in this report as presented from our studio.
The National Independent Electoral Commission had declared Governor Sule Abdullahi of APC as the winner of the governorship election of March 18 in the state. Dissatisfied with the outcome of the said election, the candidate of PDP, David Mbugadu, filed a petition before the tribunal, arguing that he won the election instead of Governor Abdullahi. During trial, Mbugadu alleged that his votes were wrongly omitted during collation from polling units, wards, local government and other state collation centers, urging the tribunal to declare him the rightful winner of the election. His allegation of non-compliance with the Electoral Act were discountenanced by the Council of INEC, APC and Governor Sule. Reading the majority judgment, Chairman of the tribunal, Ezekiel Ajayi, who added and subtracted votes, declared that Governor Sule was not validly elected and that PDP candidate David Mbugadu scored the highest number of votes in the election. The tribunal ordered INEC to withdraw certificate of return from Governor Sule and issued same to the PDP candidate David Mbugadu, who according to the tribunal won the election. However, in a dissenting judgment, a member of the tribunal, Ibrahim Mashi, dismissed the petition on ground of lack of proof and contradictory statements from witnesses brought by the petitioner. He therefore affirmed the election of Governor Abdullahi Sule.
INEC declared Alhaji Sule as the governor of Nasarawa State. Dissatisfied with the judgment, the PDP and its candidates, Honorable Emmanuel David Mbugadu, approached the tribunal on the ground that Alhaji Sule was not duly elected by majority of lawful vote cast at the election. Rather, Mbugadu was the one who indeed secured the majority of lawful vote cast at the election.
The dissenting judgment held that the governor of Nasarawa State, who is the second respondent, Engineer A.A. Sule, is the winner of the March 18, 2023 governorship election, and that he won with 3,799 valid votes.
Trust TV gathered that both parties may appeal portion of the judgment deemed unfavorable to them.
All right. Now, to talk about this and other tribunal cases ongoing across the country, we have in the studio Mr. Mutiu Akintaya. He is a legal practitioner who is going to be giving us some perspectives to this judgment. Thank you so much for joining us on Daybreak this morning.
It's my pleasure to be here. Thank you.
You know, Barrister, sometimes I see the judgments that we get, and yes, usually the members of the panel of the tribunals consist of 3 of them. Some, I would say there will be majority vote and then majority decision of the panel, and then perhaps one person will have a different view. And I'm wondering, they all have the same facts laid bare to all of them. Why are we having differences in, you know, the judgment? Or I'll say different positions.
Okay, thank you very much. To have dissenting opinion or dissenting decisions there's nothing wrong about it. From time immemorial in our jurisprudence, that has always been the case. You recall even the famous Obasanjo versus Buhari's case around 2003 or thereabout. You had 4-3 Supreme Court justices. And even in cases that are not electoral cases, you usually have majority decision and then minority decision. These judges are human beings, and the way they look at the law, they see it differently because they are human beings. And even the justices of the Supreme Court will tell you that they are human beings and they are not infallible. And that's why as lawyers we will always say the law is like an elephant. It depends on which part of the elephant you're touching. If you touch the tusk, your experience will be different. If you touch the tail, your experience will be different. So these judges are human beings, and their interpretation of the law may differ. And that's why in our jurisprudence, it's stage by stage. From the tribunal, it goes to the Court of Appeal, and then the Supreme Court. All of those stages are to ensure that different people from different backgrounds, from different experience, are able to look at the law vis-a-vis the facts placed before them to give the correct interpretation. And you know, for all of these cases, it will not end at the tribunal. It will go to the Court of Appeal. The justices will have the opportunity to sit and look at the cases, the law, the facts. It will then end up at the Supreme Court, which is the ultimate court in the land. So that's the way our jurisprudence is. You have majority decision, you have dissenting decisions.
So right now we're going to uphold the majority decision.
Yes.
But the minority decision, could that help, you know, the incumbent governor's team, you know, when taking up the situation, the case to the next court?
Okay, so where you have a panel sitting, like in this case, 3 persons or 3 judges sitting to determine a case like this, the decision of the court is the majority decision. So if any of the parties would appeal whatever part of the decision of the court, it is the majority decision that they will be focusing on. The minority decision is important, but that is not what will be appealed to the Court of Appeal. So as it is for Nasarawa State, for instance, it is the decision given by 2 members of that panel that is deemed to be the decision of the tribunal.
Okay, so let's get your own thoughts about the Nasarawa case specifically. What are your thoughts? Did the judgment come to you as a surprise? Or I'm sure you've been following events in the state.
Okay, so let me say that I've not had the opportunity to read the judgment. I was not also in the court when the judgment was delivered. So whatever I'll be saying here will be based on my knowledge of the law and what has been reported in various media outfits. So you know that in challenging election results at the tribunal, the petitioners will usually base their challenge on 3 grounds. Maybe to say the person who was announced as the winner of the election was not qualified to even contest as at the time that he or she contested, or to say INEC did not follow its own rules and guidelines, or that the election was marred by corrupt practices, or to say that the person who was announced as the winner of the election did not win majority of lawful votes cast at the election. So if you take the first ground is usually a ground of that does not go into the merit of the matter. And you will have seen that consistently from even the presidential election tribunal to the governorship, you will see that those petitioners will usually challenge the qualification of the person who was returned elected, either to say, oh, as at the time he was nominated by his party, he was not even qualified to stand for that election. And then, but the ground that is most important is to say that the person who was returned elected or announced by INEC did not score majority of lawful votes cast. And that's where the real work is. So for any petitioner who will have to prove this before the court of law, before the tribunal, will have to show mathematical calculations. And in the case of Nasarawa State, that was what the 2 members of the panel held, that the Form EC8A, which was entered at the polling units, was not the same, the results from those forms was not the same that was transmitted to the ward and then to the local government. Meaning from the polling units, there were, maybe those figures were changed until it got to the final collating center where the result was then announced. Yeah, so these are basically evidence that parties will have to bring to court. And if they're able to show that, oh, this is what our candidate had, during the election that was not calculated for him or her, the court will look at it critically. And if the court sees that, yes, so number of votes were deducted illegally from the vote of the petitioner, the court will have to bring back those votes. And if the court also finds that for the respondent, who must have been announced as the winner of the election, that there were votes that were also added up to him or her, which he did not lawfully get, the court will also deduct it. So in summary, that was what the two members of the panel did in Nasarawa State. And they came to a conclusion that after doing all of that, that they can see clearly that it was David Ombugadu who had majority of lawful votes cast.
Okay, there are two things that I've observed in the course of the sittings the tribunal sittings across the country. Yeah. Some of the judgments that have been given so far, you would find that the decision of the panel usually will say either the petitioners did not prove the case that they are making, so they did not prove sufficiently that either to say INEC actually did not comply with their own processes, or to say they did not prove that the person announced by INEC as duly elected was not actually the winner of the election. The other grounds I've seen also is to say that the case or the case that the petitioners are making is a pre-election matter. So when you hear that, first I would like for you to talk about this. Why do we hear that a case is a pre-election matter and then we're hearing that it's been filed at the tribunal?
Okay, so what we must all understand, and that even these candidates who go to court must understand, is that there is a pre-election, there is the election itself, and then there's the post-election. So every serious political party or serious candidate must prepare for these three stages. There are matters which are internal affairs of political parties, and those matters are usually pre-election matters that are heard by the Federal High Court. So if, for example, you have three members of the same political party vying for the ticket of a party in a primary election, and then maybe there are issues, they will have to deal with that issue before the election. And that's why you will see that the Federal High Court will deal with so many pre-election matters to determine whether the person who has been given the ticket of the party is the rightful person and whether that person is really qualified. So the courts have always maintained that those matters are matters that are internal to those political parties. And then anybody from outside those political parties who come to challenge the qualification of any candidate in a different political party is a meddlesome interloper. He's simply somebody who is getting himself or herself concerned with what he should not be concerned about. And that has been our jurisprudence right from time immemorial. So anybody who wants to challenge the qualification of a candidate must do that at that pre-election stage. And when the election also comes, election is usually about balloting from the polling units to the wards, to the local government, and then to the final collation center. And every political party will usually have their agents at the polling units. And when those forms are filled, they usually fill the final result at the polling units, the form EC8A. It's usually filled in duplicates. So you expect that the agents of political parties will also get those duplicate results, so that as INEC moves those results from the polling units to the ward, they will also be able to also confirm to their agents there that this is what was announced and that we witnessed at the polling unit.
So we've had cases or stories about where agents will be denied access into collation centers or centers where the announce is being announced at the ward level and so on.
Yeah, so
what do we do if you are filing a case in that?
Yeah, so what becomes important for candidates of political parties is that they have to keep their evidence. You understand? If there are issues like that, we're in an age where technology is everywhere. If you're being denied entrance into a collation center, you can do a video to show that you have been denied access to the collation center. You can also report to the appropriate quarters. If nothing is done, and at the end of the day, those figures are manipulated, all of that, you can bring them before the tribunal. And of course, the tribunal will look at them. So if anything goes wrong, it's going to be in the favor of the candidate or the political party who is challenging those results. Yes.
Barrister, let's talk about, how the petition tribunal is going for across the country, rather. We saw the tribunal oppose Governor Simina Laye for Barra's election in Rivers State. We saw the Adamawa State of Governor Fintiri. We saw how the outcome, similarly to the Nasarawa case, happened in Kano State. As a legal practitioner, what is your take on how the Governorship Petition Tribunal is panning out?
I think for me, it is good for our jurisprudence. It is good for our country. And the reason for this is that going forward, politicians will be very careful. If the people have spoken and the figures out there are clear, nobody will go pursuing shadows. Also, if the figures are clear, nobody will also go to manipulate those results, because the end of the road is not in the INEC office. It will still go to the judiciary. And the judiciary will have the opportunity to still look at the results and look at all of the evidence that will be brought before it by the candidates or by the political parties. So for me, I think it's sending a very strong message that it's not going to be business as usual. That it also tells candidates and political parties that they should not only prepare themselves for elections only, they must also prepare themselves for the post-election, which is the tribunal cases. Because you will have seen that it's possible even some of these petitioners may have good cases, but if you do not have evidence to back up these cases before the tribunal, there's absolutely nothing the tribunal can do.
Exactly. So the one question I also want to ask is that why does it appear as if it's becoming more and more difficult to prove cases when it comes to the numbers, when it comes to the results of an election, when we have a technological system introduced by INEC, talking about the IREF, for instance, that is, in my view, should be able to assist, petitioners who are making a case about, election results being manipulated. Do you think that so far the technology has helped in that regard?
Okay, so if you look at the decision of the Presidential Election Tribunal, you will have seen that the justices of the Court of Appeal already said that the IRF portal was not meant for collation of results. So what it means is that whatever is put on the IRF portal was simply for public consumption, and perhaps to just ensure there's transparency and then there's accountability. So anybody, anywhere in the country can go on the portal and see what's the result of a particular polling unit. But according to the Court of Appeal, collation is still manually done. So it's still the documents, the forms that are filled from the polling units to the ward level, to the local government, and then up to the final collation center that are really very important. But what I will say here...
So the IRF is good enough for the members of the public to view and for the sake of transparency, but it's not good enough to be used in the court of law to say, okay, these are the numbers uploaded so far, and
So I'm saying what the Court of Appeal said now. That's what the Court of Appeal held at the Presidential Election Tribunal, because you will know that one of the issues that was submitted to the Court of Appeal by both PDP and LP against the sitting president and All Progressive Congress was that there was a promise that these results were going to be uploaded on IREF.
Yeah, but what's your legal view in this regard?
I will wait until the Supreme Court will decide. I'm just saying this is what the Court of Appeal said. Yeah, so I'm sure in the next 2-3 months, the Supreme Court will decide. At the moment the Supreme Court decides, that would be the position of the law. So my opinion will not be important at that point.
I remember one of the judgment that the appeal made that's saying that they cannot enforce, or they can't force the INEC on how to make, the process of the election, which is something I think that needs to be looked upon again, because we need to review that. But thank you so much, Barrister Mutiu Akinsanya, a legal practitioner, for joining us this morning and sharing your take on the